Have you ever been told no and just desperately wanted to know why? It's a pretty universal human frustration, right? We all crave explanations. We want to understand the reasoning, especially when the stakes are incredibly high. Now, I want you to imagine that no isn't coming from your boss or a parent. It's coming from the highest courts in the land, regarding a massive legal dispute. So, does a judge always have to explain their decisions when they say no, or are there actually times when absolute silence is legally justified?
Welcome to this explainer. Today we're unpacking exactly that question by looking at a truly fascinating 1999 South African Constitutional Court case. It's Vincent Moretti Mpahlele versus the First National Bank of South Africa. And the core of this case wrestles with a massive judicial dilemma: the why behind the no and the incredible tension between transparency and efficiency in the Supreme Court. All right, let's dive right in and see how this whole debate started.
So, Section 1, the power of no. A dispute reaches the top.
Our source material centers on an attorney named Vincent Mpahlele. He was in a legal dispute over a trust account with his bank, and he ended up losing his initial case. But he didn't stop there. He started escalating the matter up the judicial ladder. Let's trace his steps really quickly. In December 1997, the High Court dismisses his initial application, with costs. 6 months roll by, and in June 1998, he tries to appeal, but the High Court denies him leave to appeal. Still undeterred, Mpahlele petitions the Chief Justice for leave to appeal to the Supreme Court of Appeal. Under their rules, 2 judges actually look at his petition and they refuse it. But, and here is the kicker, they refuse it without hearing oral arguments and without giving him a single reason. Just a flat no. That unexplained, abrupt rejection, that is exactly what sparked this entire debate, leading straight to the March 1999 Constitutional Court judgment we're looking at today.
Moving into Section 2, the constitutional challenge, echoes of the past.
Mpahlele wasn't just disappointed by this rejection, you guys. He was fundamentally aggrieved. He absolutely refused to just accept this silent dismissal. First, he writes to the Registrar of the Supreme Court of Appeal asking for reasons, and they basically tell him, hey, it's a long-standing practice not to furnish reasons here. So he escalates it. He writes directly to the Chief Justice, arguing that this so-called long-standing practice was actually an apartheid practice which was oppressive and destined to intimidate the poor masses. Now we need to impartially understand the sheer weight of this assertion. He was arguing that unexplained judicial dismissals are illegitimate relics of South Africa's pre-constitutional past, a time when the judiciary was widely seen by the majority of Black South Africans as serving only the interests of a highly oppressive state.
So he takes this all the way to the Constitutional Court, and he grounds his argument in 3 specific sections of the Constitution. First up, Section 34, the right of access to courts. His argument is that if you don't get reasons for decision, that right is completely violated. Second, Section 32, the right to information. He says, look, I'm entitled to the reasons held by the court to maintain a democracy based on openness. And finally, Section 9, the right to equality. He makes the point that civil litigation parties shouldn't be treated differently than criminal litigation parties. Ultimately, Mpahlele's stance was that this new constitution demands a total ethos of accountability from the judiciary, at literally every single level.
Which brings us to Section 3, why reasons matter, the rule of law.
Here is where we get to the judgment of Justice Goldstone, and there's actually a really fascinating twist here. Justice Goldstone completely validated the applicant's core premise. He agreed that the rule of law absolutely requires judges not to act arbitrarily. And he agreed that judiciary has a major responsibility to scrutinize pre-constitutional practices to make sure they actually fit a young democracy. So he lays out exactly why courts of first instance, meaning the lower courts, are virtually bound to explain their reasoning. Furnishing reasons does a few crucial things. It explains the decision to the parties and the public, keeping the courts open. It acts as a strict discipline that curbs arbitrary judicial decisions. It's also totally essential for the appeals process, right? You need to know if you even have grounds to appeal. And finally, it provides vital guidance for similar future matters. Justice Goldstone went as far as to note that if a lower court just withheld its reasons, that might actually be a direct violation of the constitutional right of access to courts.
All right, Section 4, the practical reality, the pragmatic pivot.
Now you might be wondering, if reasons are so undeniably crucial for justice, why on earth did the Supreme Court of Appeal not give Mpahlele any? Well, this is where Justice Goldstone introduces a pragmatic plot twist, highlighting the harsh but necessary reality of how the highest courts operate. We really have to contrast the duties here. A court of first instance has to furnish reasons to ensure accountability and enable appeals. But a court of last instance, like the Supreme Court of Appeal when considering leave to appeal, has a very different primary burden: They must control their dockets. Justice Goldstone points out it's simply not in the public interest to clog up the highest courts with unmeritorious or vexatious issues. The entire purpose of requiring leave to appeal in the first place is judicial economy. It's meant to save scarce judicial time and avoid wasting resources on cases that, frankly, have nowhere else to go.
Now, I know what you're probably thinking. Isn't that just a super convenient excuse for judges to ignore people? Actually, no. There is a built-in safeguard, and it comes down to the number 2. Before a petition for leave to appeal is denied by the Supreme Court of Appeal, at least 2 judges of that court must review the reasons already provided by the lower court. So it's not just one person hastily tossing a file into the shredder, it's a mandated multi-judge review of the lower court's documented logic.
Furthermore, that silence from the appellate court, it isn't actually silent. It carries a very specific, implied legal meaning. A refusal simply implies that the order of the court below is correct and has no reasonable prospect of success. It means those 2 appellate judges looked closely at the lower court's work, evaluated the arguments, and agreed that the legal road had officially ended. Writing a brand new judgment just to say, hey, we agree with the other judge and this has 0 chance of succeeding, well, that would completely defeat the purpose of having a filter for unmeritorious cases in the first place.
Let's look at Section 5, the final verdict. Balancing justice and efficiency.
So how did the Constitutional Court ultimately balance these competing ideals, transparency versus efficiency? Let's walk through the logical steps Justice Goldstone laid out to show that Mpahlele's rights were in fact respected the entire time. Step 1. The lower court provided full, detailed reasons for dismissing the original application. Step 2. 2 Supreme Court of Appeal judges actively reviewed those exact reasons. And Step 3. A final refusal was issued because they found no reasonable prospects of success. The absolutely crucial takeaway here is that the applicant actually did receive his constitutional right to reasons. He got them at the very start of his journey from the court of first instance. The Supreme Court of Appeal's refusal simply confirmed those existing reasons.
Addressing Mpahlele's other specific constitutional arguments, Justice Goldstone found them a bit misplaced in this context. First, regarding equality, he noted that this procedure, not giving reasons for refusing leave to appeal, applies equally to both civil and criminal cases, so there's literally no discrimination happening there. Second, regarding the right to information, the Constitution says information must be required for the exercise or protection of a right. But because a refusal by the Supreme Court of Appeal is final and you can't appeal it to any other court, the legal road has ended. Even if the court generated brand new reasons for him, he wouldn't be able to use them to claim any subsequent right.
And so we arrive at the final verdict. The application was officially dismissed. The Constitutional Court found no breach of the Constitution, concluding that the practice of not providing reasons for refusing leave to appeal is perfectly consistent with an open and democratic society. But, in a very telling move, Justice Goldstone made no order as to costs. Usually the loser has to pay the winner's legal fees, right? But the court uniquely dropped the costs here. They did this to recognize that the issue Mpahlele raised, demanding judicial accountability in a post-apartheid democracy, was a profoundly important constitutional question, and it was one he was fully entitled to bring forward.
Which leaves us with this final, lingering thought. This 1999 ruling brilliantly highlights a tension that exists in pretty much every modern democracy. On one hand, we demand total accountability, but on the other, we desperately require a justice system that actually functions, one that doesn't just collapse under the weight of its own procedures. If absolute transparency literally paralyzes the justice system, where do we draw the line between fairness and efficiency? It's a really delicate balance between the ideal of endless explanation and the harsh reality of finite time. Thank you so much for joining me on this explainer. I hope this deep dive into the source material leaves you with a whole lot to think about the next time you hear a simple, unexplained no.